Okay, it looks like everyone is in. I'm going to start the session. So welcome to session 7, providing the enabling environment for environmental defenders, the role of procedural rights. I want to start with an acknowledgement of the country that I live on. I'm on the traditional lands of the Gadigal peoples of the Eora Nation in Sydney, Australia. I acknowledge the elders past, present and emerging and recognise that sovereignty was never ceded. So my name's Fleur Ramsay. I'm moderating the session. I'm Special Counsel in the International Program at the Environmental Defenders Office, where we work predominantly, or at least the International Program works predominantly in Oceania. Environmental Defenders Office is based in Australia. I am an Aotearoa New Zealand-born Samoan. My expertise is Indigenous rights and environmental law, and I have extensive litigation experience. Before I formally start the session, I want to deal with some administrative matters first. So I'm just going to remind everyone that the meeting is held under the Chatham House rule, which means that participants are free to use the information received, but neither the identity nor the affiliation of the speakers nor that of any other participant may be revealed. I'd also like to note that this meeting is being recorded. We have 4 speakers today, and I will introduce each speaker as I invite them to speak. They will have 10 minutes to speak. And at the end of the invited speakers, we'll have around about 40 minutes for Q&A and discussion, which will give us hopefully a lot of time to discuss, which I think is a really important issue for the Pacifica region. So I just wanted to set the scene before we started, before I invite the speakers to speak. So the question I wanted to start with was, what does an enabling environment for environmental defenders look like in the Pacifica region? The Aarhus Convention, which is an EU convention on procedural rights in environmental matters, has 3 pillars: access to environmental information, public participation and decision-making, and access to justice. These 3 pillars are an important starting point, and we will be discussing the challenges of achieving these rights in the Pacifica region. However, I wanted to start and look at the region for inspiration first. We will be hearing from a Papua New Guinean speaker today, Mr. Bosip, and I should add that that's an area that I work in. It has a visionary constitution, which includes a right to freedom of information guaranteed in the constitution. It ensures access to justice in human rights cases, and it outlines environmental principles such as intergenerational equity that all decision makers, including the judiciary, are required to take into account. However, despite a constitutionally guaranteed right to information, basic environmental information such as environmental permits is not made available to the public and undermines the rule of law and the ability of environmental defenders to ensure that the decisions are being made according to law. In another area that I've worked in the Solomons, the Environment Act provides for a merits review process, which had never been constituted until very recently, when the residents of Wagina Island forced the issue by taking court proceedings, and the first merits review decision by the newly constituted body was decided last year, rejecting a bauxite mine on Wagina Island, and is an exemplary example of excellent and well-reasoned environmental decision-making. So therefore, the first step for us in Pacifica is to strengthen what already exists on the local level. But then I have a number of questions that I want to ask to set the scene. Is there a role for a convention like Aarhus in the region? And is it the best model for Pacifica? What about UNDRIP, the UN Declaration of the Rights of Indigenous Peoples, and particularly the key procedural and substantive right of free, prior and informed consent? Is UNDRIP and FPIC relevant to Pacifica, particularly in countries where colonial ties have been formally severed and the Indigenous peoples are not minorities? What does customary law have? What role does it have as enabling conditions for environmental defenders? And how can this be incorporated into state legal systems? What about local decision-making institutions? And can these institutions be used in environmental decision-making or as a method of public participation? Can we indigenize Althos Convention? What does FPIC look like in the Pacifica? These are some of the questions I wanted to start with, and I'm sure the speakers will generate many more and provide an opportunity for a rich discussion in the Q&A. So I'm going to invite the first speaker, which is Dr. Georgina Lloyd Rivera, Regional Coordinator of the Environmental Law and Governance, UNEP. Dr. Georgina Lloyd Rivera is the Regional Coordinator, Asia and the Pacific of Environmental Law and Governance for the United Nations Environment Programme. Georgina's work covers the areas of environmental rights, environmental crime, technical assistance in environmental law, and capacity building at the national and regional level. Georgina has been involved in capacity building for environmental law within Southeast Asia and has provided advice on government and non-government stakeholders on environmental law and policy issues. Georgina holds a PhD in law, Master in Environmental Law and a Bachelor in Environmental Science, Honours 1 from the University of Sydney. Georgina is going to talk to us today about what ways the promotion and protection of procedural rights, in what ways are the promotion and protection of procedural rights fundamental for creation of an enabling environment? Thank you.
Thank you so much, Fleur, for the introduction. And I'm really happy to take the floor again during this workshop to talk about this really important topic. And this session is the final session of the workshop. And I think it's good to reflect at this point on procedural rights, because we've heard throughout the workshop several times that environmental human rights defenders are increasingly under threat for their work to protect the environment and advocate for sustainable and equitable use of natural resources. Yesterday, we had Forum Asia who reported on 30 killings of the EHRDs in the Asian region from 2019 to 2020. Global Witness reported that 2019 was the deadliest year on record for EHRDs, recording. We've heard numerous accounts during the sessions of the 2 days of persecution and violence, noting particularly that women and girls and Indigenous peoples face heightened risks. And Fleur's questions around customary law and around recognition of free, prior, informed consent are critical elements to consider across the Pacific. So given this situation, it is clear that legal protection of environmental human rights defenders requires urgent attention throughout the region. And that is the main premise that I'm going to keep coming back to. The discussions during the sessions of the last few days have clearly shown that there is not currently a safe and enabling environment for EHRDs. And it is vital to have such an enabling environment. And furthermore, such an environment will likely not be achieved through just policy responses and soft law agreements. In this meeting, we have heard that some countries who have policy instruments or soft laws in place or regional soft law agreements to protect HRDs or to prevent SLAP suits, for example, strategic lawsuits against public participation, such as, for example, we heard about Thailand's National Action Plan on Business and Human Rights that has specific provisions on human rights defenders and on the environment. These countries continue to have high rates of criminalization and violence against those who advocate for the environment and are champions of environmental justice. So I come back to the point that there needs to be legal protection, legally binding protection of environmental human rights defenders. Putting in place an enabling environment is closely linked to the achievement of SDG 16. And I think a couple of other speakers are going to touch on this as well. Of course, the Sustainable Development Goal 16 includes elements of an effective environmental rule of law, contributing to the promotion of peaceful and inclusive societies for sustainable development, access to justice for all, and the building of effective transparent, accountable, and inclusive institutions. Earlier this year, UNEP released a brief on SDG 16, environmental rule of law and human rights. And this brief stipulates that an enabling environment for environmental defenders is one that is consistent with environmental rule of law. It requires the greater implementation of a gender responsive and rights-based approach in environmental decision-making. There is quite a bit of detail within this brief, and I'm not going to go into all of the elements of it. So I think it is going to be shared or has already been shared in the chat box. And I want to mention that we've been working very closely in this area of work at UNEP on the protection of environmental human rights defenders across the region with Professor Ben Boer at the University of Sydney and Wuhan University. Garnering strong political will for such an approach, an approach that is a legally binding approach that to provide this enabling environment requires a shift in discourse. It requires a shift in mindset towards all actors, including government actors, seeing EHRDs as positive forces, champions for the planet, core partners in achieving sustainable development, and safeguards for the world in which we will give to future generations. There needs to be a complete shift away from EHRDs being seen as anti-development and threats to government, because they are not. They are undertaking peaceful, legitimate work that is seeking to provide a sustainable future for us all. One of the critical pillars of protection of EHRDs is the protection, promotion, and safeguarding of procedural rights. Fleur has already introduced these rights. They are rights to participation, access to information, free, prior, and informed consent, and including freedom of expression. Adequate procedural rights are essential in order to promote, respect, and protect our substantive environmental rights, including rights to land, access to natural resources, and the right to a safe, clean, healthy, and sustainable environment, particularly, of course, for persons and groups in vulnerable situations. Across the Pacific region, we've also heard from a number of participants at this workshop that Indigenous and local communities and civil society in general do not have adequate access to information or effective and fair opportunities to participate in environmental governance. We have heard that there are times when indeed there might be a legislative provision that requires community consultation for EIA, for example. And communities might protest an EIA that has been granted on the basis of the failure to undertake that consultation. However, sometimes it has been done, but it's been done in such a manner that is subversive and is not fully participatory, and the community is not informed of the process that is taking place. It is not full and effective participation. It is thus necessary to advance rights-based approaches that include these procedural elements of access to information and justice, as well as putting in place the enabling environment for our substantive rights to a healthy environment. I'm going to come back to what Fleur was mentioning, and she referenced the Aarhus Convention. And yesterday during sessions, it was asked in the chat box if the Pacific needs a regional agreement like the ESCAZU agreement. Of course, these two agreements being very similar, but the ESCAZU, and whether or not this agreement will enable better protection of environmental defenders, environmental decision-making, and access to justice. Is such an approach practical for the Pacific? I would say yes. And as I mentioned at the beginning, the legal protection, the legally binding protection of environmental human rights defenders requires urgent attention throughout the Pacific. And a legally binding agreement such as Aarhus or ESCAZU agreement, and of course the ESCAZU agreement, which entered into force in April 22nd of this year, Such agreements to protect and promote access to information, public participation, and access to justice would invariably facilitate civil society participation in environmental decision-making and support grassroots action to protect the environment. Of course, recognizing that these things are just instruments, they have to be enforced, they have to be implemented. And of course, that such instruments should include robust human rights grievance mechanisms and specific provisions concerning EHRDs. But of course, it would be a huge way forward than what is currently in place, which of course is that there is not a regional approach or a regional binding agreement. The rights of access to information, public participation, and access to justice, along with freedom of expression, association, and assembly, provide the very basis for action by defenders and are often targeted by governments, as we have seen in regional trends on shrinking civic space across the Asia Pacific. The UN guidance note on the protection and promotion of civic space notes that vibrant civic space requires an open, secure, and safe environment that is free from all acts of intimidation, harassment, and reprisals, whether online or offline. So we know that this is what we need, and this is what needs to be achieved. The thing is that I think almost all of us, if not all of us in this space, understand and agree on this point. We understand and agree on the significance and the need for protection of procedural rights. But what we need to discuss now is what next? What are the collective actions that we need to take to move towards legal protection of these rights? And in conclusion of my intervention, I would like to suggest 5 points. And I really hope throughout the session, we can explore other points. And please, I would really like to hear some other suggestions in the chat box. So the first suggestion that I would put forward is at an intergovernmental level, UN entities such as UNEP and OHCHR can continue to convene and create space for discussions to advance the building of consensus around such approaches that protect procedural rights. Space, of course, that is not just for states, but for bringing all stakeholders around the table, especially including the voices of EHRDs, women, Indigenous peoples, and youth. The second suggestion is that we can continue to build on the dialogue at all scales, talking to local community leaders, pushing journalistic pieces, bringing conversations to regional forums. And there was a really important intervention yesterday by a Pacific journalist who spoke about the lack of time and capacity of journalists in the Pacific to research and to go into depth on environmental matters because they're expected to report on such a wide variety of matters and their teams are so small. And so doing the research ourselves, having those journalistic pieces that we can share with journalists to raise awareness, I think is a key practical step that can be taken. Third, we can continue to raise awareness of key members of the executive, judicial, and legislative arms of government through both formal programs and informal approaches. For example, we can continue to hold judicial capacity building programs that create and raise awareness of the linkages between environmental law and human rights bodies of law. The interlinkages now are becoming clearer and they are being clearly established, but yet there is a need for increasing awareness raising amongst a number of key stakeholders on these close interlinkages between human rights and the environment. Fourth, we can work and continue to identify human rights abuses, condemn them when they occur, and where possible and to the best of our ability, hold perpetrators to account. This includes utilizing the existing special procedures mechanisms. It includes using legal mechanisms that are in place available at the national level. And by building on networks and sharing of information, we can continue to work to the extent possible to hold perpetrators to account. Fifth and finally, continue to build solidarity networks to access peer-to-peer exchange, share technical support and training, and share ways to safeguard procedural rights and exercise these rights. It was suggested just in the earlier session before this one that was all about EHRD network building and the sustainability of such networks. That working towards a common goal, indeed, perhaps like the establishment of a regional agreement on access rights or procedural rights, might be something that could be a source of inspiration and the key action point for such a regional network. So with those, Fleur, I hope I did raise a few more questions as well as give a few ideas, and I will hand the floor back to you. Thank you so much.
Thank you. Okay, so our second speaker today is Matthew Baird, Director of the Asia Research Institute for Environmental Law. Matthew has been an environmental lawyer with over 30 years experience. He's worked extensively in the Asia Pacific region with UNEP, ADB, IFC, Vermont Law School, the European Union and USAID. He has attended and presented on a number of workshops on human rights and the environment and seminars on environmental human rights defenders. He was a lead author with UNESCAP and UNEP on a recent technical briefing paper called An Assessment of Access to Information, Public Participation and Access to Justice and Environmental Decision-Making in Asia Pacific. He is a visiting scholar at Vermont Law School, an honorary research fellow with the Myanmar Centre for Responsible Business, a certified environmental practitioner, and a fellow of the Environment Institute of Australia and New Zealand. Matthew today is going to talk to us about what is the current status of access rights in the Pacific and what are some opportunities for protection of access rights across Oceania. Thank you, Matthew.
Thank you very much, Fleur, for that very kind introduction, and also for your initial questions, your mentioning of the Aarhus Convention and the UN Declaration of the Rights of Indigenous People. And I thought it was also very interesting, the question of free, prior, informed consent for Indigenous people. How does that necessarily relate to decision-making that might be taken in Pacifica? Where, as you say, where Indigenous people are a dominant community. The other issue, I think, which is very important is, of course, all of the post-colonial framework, the role of Australia, New Zealand, the United States, Europe, China, within Pacifica, and how that can be used both good and for bad. And I also think it's very important to note that in relation to access rights, the Aarhus Convention, which was a European Economic Community, an ECE, sorry, the European Commission on, European Economic Commission, that it was a UN body that started the Aarhus Convention that's now become available for every country to sign up. The Escazú Agreement, which is for Latin America and the Caribbean, has again gone further in some respects than Aarhus, because it also talks about the right to a safe environment, and also it talks about the role of an enabling environment and the protection of environmental human rights defenders. So I just wanted to be very, to briefly share my screen and a very short presentation looking at some of the key issues. So I've been asked to sort of look about at what has the status of access rights in the Pacific. So the technical briefing that was released at an ASEAN Intergovernmental Committee last week, which we will be able to share with the participants soon, looked at a number of key elements in terms of access to information, public participation and access to justice in environmental decision-making in the Asia-Pacific region. But it also looked internationally, in particular at Africa and Latin America, where there have been some interesting developments in the protection of human rights and the environment. In terms of the Pacific, I think it's no surprise that access rights is in a little bit of a dire state in the Pacific. As you mentioned, even in your introduction, issues of freedom of information that might be constitutionally guaranteed may not be able to be effectively or activated or accessed by people. The recognition of a right to a healthy environment in Fiji may also not be something that can be brought either to the courts or decision makers. And in New Zealand, we've seen recognition of legal rights of nature, which again happened very early of Maori and Indigenous culture in terms of tangia and other intrinsic values of the environment that was trying to be brought into a colonialist legal system. And that of course occurred in some ways in good areas, but in other ways it was less successful. In terms of in Australia, we also can identify that native title, an attempt to codify native title and Indigenous rights after the Mabo decision in 1993 has been in some areas successful and in other areas very, very unsuccessful. Has it achieved Indigenous protection of Indigenous people and guaranteeing of rights? I think the answer is clearly no in Australia. And certainly we've seen now a case where the Torres Strait Islanders are bringing cases against the Australian government for failure to take action on environmental matters, in particular climate change. It is also to remember in the context of access rights that in Australia, Australia's anti-protest laws are some of the most draconian in the world. The attempts to support freedom of expression and freedom of protest, peaceful protest, have been ruthlessly crushed by many governments, whether in Tasmania or New South Wales. And it's interesting that many of these things, including laws prescribing grandmothers from knitting outside parliamentarians' offices in protest, and they predated COVID. So COVID has been used as a mechanism to restrict further certain degrees of expression and public protest in the interest of public health. But in Australia, many of those restrictions were predated through attempts to control and limit environmental protests. But there's also some interesting opportunities that have been identified in the Asia Pacific. The Asian Development Bank, for example, which is a very significant lender in the Pacifica region, has an access to information policy that is considered one of the best in terms of providing for broad-scale access to information as it affects activities of the Asian Development Bank. It provides for a grievance redress mechanism whereby independent assessors can address any attempts to restrict those information, but it also has principles of disclosure. So the principles are for open disclosure of information. And this is quite important because as a major development partner within the region, this can be used to also influence potential other stakeholders like the IFC, the Asian Development Bank and the Asian Infrastructure Investment Bank, and the Chinese Exim banks and other development partners within that region. We've also seen the creation of the Pacific Environment Portal, which has also provided an opportunity to access that information. Again, the information also needs to be freely available to be able to be uploaded on those sort of data portals. And then communities need to also understand what is available. There have also been moves on environmental impact assessment. And while I don't believe that environmental impact assessment or project-based impact assessment is necessarily the only avenue for accessing information, it's often very important for specific projects, development projects, tourism projects, infrastructure projects that have big environmental and social impacts. So it's still a very, very important tool. There has been moves to have greater guidelines for the Pacifica area, that can be applied amongst all countries, and that includes access to information, meaningful public participation, and indeed access to remedies if those access rights are not found available. But at the same time, we also have issues about transboundary environmental impact assessment, which is a norm of international environmental law, but may have challenges in the Pacific countries. EIA is also beset by a number of capacity development problems. Often the developers and the proponents have significantly more environmental impact assessment experience than some of the regulators, and that creates its own significant challenges in terms of procedural rights. The other issue that I also wanted to identify, and this is something that was also identified by Fleur, is in terms of the document that we prepared and the recommendations. We looked at these 5 particular areas in terms of 4 recommendations, and I wanted just to highlight a few potential recommendations for the Pacifica region. One which also developed out of a ADB UNEP conference 2 years ago was the idea of a Pacific Environmental Court. This was held in Fiji before COVID and gained a great deal of interest from the judges in the region about this idea of dealing with a number of issues, environmental and social issues that relate across borders or that have regional impacts. Another issue that was considered as being very important for access rights is free, prior, informed consent as a precondition to environmental decision making. Under the Declaration of the Rights of Indigenous People, this is mostly restricted to a right for Indigenous people. But in terms of the role of Indigenous people in the Pacifica, this could be a precondition to all environmental decision making, the need to obtain consent in a particular way from those rights holders. The question then arises, who makes those decisions? And I think we've heard over the last 2 days that there are still challenges to traditional means of decision making, whereby chiefs and chieftains may often and head people of villages may exercise undue influence over communities, which is certainly not the basis of FPIC, which is meant to really support community decision making. And that also includes issues of gender and youth, how they are effectively engaged and given meaningful opportunities to participate and or consent or withhold consent, which is of course a very important part of FPIC. The other question is this idea of a declaration on access rights and an enabling environment for environmental and human rights defenders. And this is this idea that was raised yesterday in the chat about the EHRDs agreement that Fleur raised in terms of the OHCHR agreement. The idea of, is it time for a Pacifica declaration on access rights and enabling environment, looking to the EHRDs agreement from Latin America and the Caribbean, but also looking at the OHCHR Convention from the ECE. And finally, the opportunity and the mechanism that might be used could be a protocol under the Convention of the Protection of Nature, of Environment and Natural Resources from 1986. The Noumea Convention does have an opportunity for protocols to be developed in and under that convention. And one mechanism by which we could look at supporting access rights and procedural rights, and indeed the rights of environmental and human rights defenders, might be a protocol that can be developed and negotiated under that convention, which would then provide a very good procedural and legal basis for supporting environmental human rights defenders in the context of supporting procedural rights and giving legal recognition to those procedural rights. Thank you very much indeed for the opportunity to present today. Thanks, Fleur.
Thank you, Matthew. So I'm going to move on to our third speaker. Peter Bosip is the CEO of the Centre for Environmental Law and Community Rights in Papua New Guinea. Mr. Bosip is a strong voice and presence in the civil society sector, particularly in the areas of conservation, biodiversity protection, forestry, environmental sustainable development and human rights in Papua New Guinea. Peter has worked extensively in PNG over the past 21 years and currently holds the role of CEO of the Centre for Environmental Law and Community Rights, a role that he's held for the past 9 years. Peter holds a Bachelor of Science degree from the University of Papua New Guinea and a postgraduate diploma in science and a Masters of Science degree from the University of Canterbury. Peter currently sits as the President of the Board of the PNG Resource Governance Coalition and as well serving as a Majlis Council member overseeing the Asia Pacific region for the Friends of the Earth International. Peter, I'll hand the floor to you.
Thank you, Fleur, for this introduction. Firstly, I would like, as part of the introductory notes, I would like to introduce my organization, the Center for Environmental and Community Rights, or CELCO in short. Is a public interest law firm that has been in practice for well over 20 years. And we have been working throughout Papua New Guinea, serving rural and marginalized communities. And the service that we provide are basically legal aid, legal education, advocacy, and lobbying. And we have a total of 5 in-house lawyers and also 4 community legal education and advocacy or lobbying team, and that makes a total of 8 full-time staff plus the support, which is the finance and admin team. So we are a total of 15 staff altogether, working in CELCO. And the topic that will be discussed, or I'll be talking, is on the human rights defenders. So I'll be focusing on the legal aid aspect of our work. And while we are working in PNG, we also lack expertise or experienced lawyers. So we have an arrangement in place. I think, Fleur, you are well aware of that, which you are part of the, assisting team from EDO, Environmental Defenders Office in Australia, basically the team based in Sydney, providing support to CELCO's work here in PNG. So that's basic introduction to CELCO. And in this brief presentation, I will speak on 2 related questions posed by the moderator, which is the current barriers to implementing access to information, public participation, and access to justice in the Pacific, and what are some of the solutions to these barriers. So firstly, let me respond to the 2 questions by way of making a number of or stating some number of points that are kind of in response to these questions. First, Papua New Guinea has a national constitution that is vibrant and guides the operations and management of our national affairs. Under this constitution, there are 5 goals and directive principles that gives rise to a sovereign nation. However, I will only focus on or state the 3 goals that are relevant to this subject of discussion. And they are goal number 1, which is the integral human development, liberation and fulfillment. And this goal number 1 states that all activities of the state should be directed towards the personal liberation and fulfillment of every citizen, so that each man and woman will have the opportunity of improving himself or herself as a whole person and achieving integral human development. Goal number 2 states the equality and participation and that is all citizens should have an equal opportunity to participate in and benefit from the development of our country. Goal number 4, which is relevant to this discussion, is the national natural resources and the environment. The natural resources and the environment of Papua New Guinea should be conceived and used for the collective benefits of the people, and should be replenished in the interest of future generations. So these 3 goals, they basically, talk about integral human development and equal participation, equality, and the conservation of the resources and the environment. However, despite the 3 goals that saying was the equal participation and conservation and the integral human development, and the exercise of the human rights, there are certain natural resource laws that do not take into account these goals. For instance, the Forestry Act, 1991, the Forestry Act, there is no provision in this act that states equal participation and application of free, prior, and informed consent principle. Further, with the lack of provision of the EPIC of free, prior, and informed consent, and no legislation on access to public information, state agencies plus multinational corporations collaborate to ignore the basic rights by restricting the accessibility of public information, such as terms and conditions of the environment permit and the mining licenses that are given to mine operators, or the environment permit given to the logging operator, for example. So the terms and conditions that are contained in these permits have not been made easily accessible by the public. Further to that, law enforcing agencies like police have used brutal force to stop landowning communities to voice their concerns on the ways in which the businesses are operating, because they were never been a part of the negotiation team, while their way of life have been negatively affected. For instance, destruction of food gardens, pollution of rivers and freshwater systems, soil erosion, and lack of local building and construction materials. These are some of these examples of negative impacts that has been brought about by large-scale development activities that have never given consent by the majority, 75% of the population. So the policemen have arrested and attacked those local landowners that have stood up to defend their community and property rights. Fourthly, while encountering this brutal forces and lack of equal participation and deprivation of access to public documents, the local communities cannot do much, as they are basically villages, and the access to seek redress is very slim, as the cost of engaging a private law firm is very expensive, while the office of the public solicitor is situated further away from the village. Basically, it is situated in urban center. Therefore, they have become a mere spectator or spectators on their own customary lands, while the multinational corporations have raped the forest resources, depriving the human rights This is an ongoing issue currently faced by the customary landowners in Papua New Guinea. So in response to question 2, there is some of the solutions. Well, what would be the solution? I think there are 2 practical experience that CELCO has experienced while working in Papua New Guinea, helping customary landowners as well as state agencies to improve the legislation and the policies aspect of work. First point is knowing the lack of access to legal support by affected customary landowners. CELCO established itself to represent those who are negatively affected by forestry and mining development projects throughout Papua New Guinea. So far, we have successfully stopped about 6 logging operations, while 2 most destructive practice of mining operations that were proposed are on hold. Further, the communities can now speak up freely, which force state agencies to review and amend certain natural resource legislations such as the Forestry Act 1991, Climate Change Act 2015, and Environment Act 2000. The amendments will see the provisions, the amendment will see the EPIC, pre-prior and informed consent provisions captured in this laws, because CELCO with other civil society organizations are directly involved in the review of these legislations and the amendment part of it. The second point is further to the discussions by the multi-stakeholder groups under the Open Government Partnership that led to the proposal on the drafting of the Freedom of Information Bill, or FOI. The FOI bill will strengthen the Section 51 of the Constitution that stipulates the access to information. PNG do have a constitution that allows for access to information, but in practice, there is no legislation that will strengthen or empower this constitution as Section 51, where it will allow or legally enable or provide some mandatory provision for the state agencies or the multinational corporations or developers to provide those public documents. So what CELCO with other civil society organizations in partnership with the Transparency International, Papua New Guinea, and the Department of Information, Communication and Technology have agreed to draft the Freedom of Information Bill. The discussion and development of strategies have taken place towards the 4th quarter of 2019. However, the COVID-19 plus the slight change in government plans have affected the progress until this month that we have revived the discussion. And a meeting with the legal officer in ICT, or Information Communication Technologies, set for this Thursday, which we hope it will enable us to proceed again towards the drafting of the bill. So the 2 solutions are, one is the amendment of current natural resource legislations, which will see the inclusion of pre-prior informed consent, that's giving rise to landowners being equally or fully participating in the discussion, planning, and development of the resources, where they will give consent, while at the same time, the Section 51 of the National Constitution that stipulates the access to information will have a mandatory provision of access to public information when the Freedom of Information Bill is drafted and finally becomes a law. So these are two practical ways that we see will enable or support the environmental defenders in Papua New Guinea to have access to information and participate equally in the development of the natural resources that they own under the customary own rights. I think that's all I have to share with everyone this afternoon. Thank you.
Thank you very much, Peter, for that. Okay, so our last speaker today is Roberto Cadiz, Commissioner of the National Human Rights Commission of the Philippines. Commissioner Cadiz was appointed to the Commission on Human Rights of the Philippines in 2015, where he now handles business and human rights, sustainable development goals, crisis and conflict, international humanitarian law and peace. He also supervised the Human Rights Policy Advisory Office. Commissioner Cadiz chaired the Philippine Human Rights Commission's inquiry panel, which investigated the impact of climate change on human rights, which pioneered the conduct of a global inquiry process for national human rights institutes, where hearings were conducted by their commission beyond the territory of the Philippines. He advocates for the formation of international human rights institute panels for the conduct of joint inquiries on issues imbued with transboundary elements and extraterritorial obligations. Prior to joining the Commission, his affiliations and advocacies included leading a campaign finance monitoring consortium, chairmanship in a transparency and accountability network, and membership in the Supreme Court Appointments Watch Coalition. Commissioner Cadiz obtained his bachelor's degree in philosophy and law from the University of Philippines. Commissioner Cadiz will talk about what is the role the National Human Rights Institutes can play in creating an enabling environment for environmental defenders. I hand the floor over to you.
Thank you very much for that introduction. So let me begin my presentation with two stark realities in regard to the topic assigned to me. The first stark reality is that businesses, if left to their own devices, will tend to compromise or sacrifice the environment in favor of profits. This is a stark reality that we see all over the globe, especially in third world or developing countries. The second stark reality is that there is actually no parity between business enterprises and communities whose environment are subjected to what we refer to as developmental aggression. Specifically, to cite a few examples, we refer to the mining industry, to the lumber industry, and even to the cattle industry. But there are many other more businesses that are engaged in developmental aggression against communities that would invariably tend to sacrifice the environment in such communities. And the executive regulatory agencies are supposed to have been created to curb this natural tendency on the part of businesses to go for profits and to every once in a while, or even oftentimes, ignore environmental concerns. But the problem is, especially in my country and in poor countries, state regulatory agencies that are supposed to protect the environment and communities are often captured by huge business interests. And this capture is often can happen in two basic instances. One is outright witting capture, where you will see strong lobbying efforts on the part of businesses to promote their businesses as against environmental concerns, and sometimes even through outright corruption or bribery of government agents and the institutions. This can also happen insidiously, sometimes unwittingly, by the sheer circumstance of environmental human rights defenders not being properly represented within the regulatory agencies, just by sheer poverty, lack of resources. They just are not present to advocate strongly enough the protection of the environment. And by their sheer absence, by the sheer lack of representation within these regulatory agencies, the environment of environmental degradation are easily promoted. When these regulatory agencies are captured or fail to protect the environment, or are captured by the big businesses, the remedy of environmental human rights defenders, or human rights defenders in general, is supposed to be found in courts. Hypothetically, courts are state-based judicial mechanisms where aggrieved parties can run to and seek relief. But this is, especially in the case of environmental degradation, this kind of remedies more hypothetical than real, for so many reasons. Although admittedly, on several occasions, courts are able to intervene and do protect the environment, but this is by and large only in regard to celebrated cases. Of cases involving environmental protection, courts sometimes are too slow to act or to intervene before it is too late. So realistically, courts are not really that accessible to environmental human rights defenders, especially when businesses, having identified certain areas and start to move in, and they tend to move in pretty quickly because of the huge resources available to them. By the time courts are able to really take action, much harm has already been done, aside to technical, over and above their slow response. And this is where NHRIs can come in. They can fill in the gaps that courts cannot provide adequately to environmental human rights defenders. So in a very, very real sense, NHRIs do complement the courts in providing access to remedies to environmental human rights defenders. One way by which NHRIs can fill in the gap is by simply elaborating on rights around the remedies through policy advisories. Courts normally resolve issues brought to them by parties. And if issues are not clearly brought to them, then courts will not delve into those issues. But NHRIs can even tackle collateral issues that they deem are relevant to the issue that has been directly brought before them by, say, environmental human rights defenders. So in the field of elaboration of human rights that can educate not only courts themselves, but even policymakers within both the legislative and executive departments, this is a very important educational function of NHRIs that will inform all these agencies and even affected parties about what their rights entail what they're entitled to. Aside from that, courts can also promote compliance by governments and businesses in respect of these procedural rights through proactive intervention in the handling of cases where they can require governments and businesses to comply with their duties and responsibilities in regard to human rights, especially as guided under the guiding principles on business and human rights. The other advantage of NHRIs is that they have convening authority. NHRIs are state-based non-judicial mechanisms for providing access to justice, and they have certain entitlements and protection as elaborated under the Paris principles, and that they can use this vast goodwill and authority and international recognition as leverage to expose business abuses and lack of performance on the part of governments in performing their duties to protect the environment. So these are some of the levers that are available to NHRIs. The other very, very clear and expansive authority of NHRIs is in their mandate to conduct national inquiries. And in the conduct of national inquiries, they can actually summon or issue subpoenas to all implicated parties to appear before them and explain and defend themselves in regard to the human rights environment, for example, for them to explain and elaborate on their position. And the NHRIs can call not only on the businesses, but call on the government why they are failing to fulfill their duty to protect the environment as elaborated, as is required of them under international law, treaties and conventions under international human rights law. NHRIs can also engage the media. And there are so many meta strategies where NHRIs can step up and promote the environment. They can call press conferences, expose certain abuses which are not available to courts. Courts will never call up press conferences and call attention. The courts are very private, but NHRIs can do that and expose all these abuses. The message that I want to say here is that given the nature of NHRIs, the remedies available to them are so vast and are only limited by their commitment and by their imagination. If they're as committed and if they're as imaginative as ideally they should be, then the greater the protection will be to the environment and to human rights defenders. In the conduct of national inquiries, they also have great leeway in defining their processes. Unlike courts where processes are clearly defined under the rules of court, NHRIs are not that strictly limited. They can combine they can immediately conduct community dialogues. They can call roundtable discussions. They can even go global and seek international experts as we have done when we conducted our national inquiry on climate change. Even as we were just a small human rights institution in a small country, it did not prevent us to expand our national inquiry actually into a global process where we were able to rely on the expertise, legal, scientific, and even governance expertise of many resources around the globe. So they can NHRIs can combine all these techniques and mechanisms for the protection or better protection of the environment and the environmental human rights defenders. NHRIs can also collaborate with other NHRIs in what we are now advocating, in which we call as inter-NHRI inquiry panels, because as we know, especially in regard to environmental issues, many of these issues are actually already global. They're not local issues, they're global issues, and it makes sense for NHRIs to come together in the conduct of a joint inter-NHRI inquiry in tackling or essaying these global environmental issues. And in that manner, whatever findings they have and whatever recommendations that they come up with, will have more gravitas, will have more acceptance, will have more respect by the global community, just because there are more NHRIs involved in the inquiry. Now, in the context of climate change as an environmental issue, what is the role of NHRIs? How can they help? Well, let me first say that the climate system is part of the global environmental system, and that global warming is adversely impacting the environment and practically the whole gamut of human rights. And this is the entry point of national human rights institutions for intervening on the issue of climate change. In that specific context, NHRIs must now play a lead role in moving their governments to address the challenges posed by climate change. And primarily, we are advocating that one of the roles that NHRIs must do is to expose all efforts by businesses and by governments, all efforts that tend to obstruct or delay the transition of the global economy from dirty fossil fuel to clean renewable energy. I will end there. I hope I did not exceed my 10 minutes. Thank you very much.
Thank you. Thank you for the 4 speakers. Yeah, I just actually got a lot out of that session, and a lot of really interesting questions for the Pacific and ways that we can deal with, you know, the question of what a proper enabling environment is, some of the barriers in the region, and then some of the solutions. So I thank the speakers for that. We've gone a little bit over time, so I think we probably have about 20 minutes for a Q&A session. I just wanted to see if anyone wanted to ask any questions, but I just ask that when you ask a question, you can state your name and affiliation, but it's not mandatory to do so. So does anyone have any questions? And perhaps if you are asking questions, you can ask the question of a particular speaker, or you can ask the question in a general way and one of the speakers may pick it up, or you could also just offer a reflection or an intervention.
So the first question was, how can national and multinational perpetrators of the environmental damage to Pacific communities be brought to account? And what legal mechanisms are available for this?
So I might just open that up to any of the speakers to answer if they have any thoughts on this. I mean, this is obviously a particularly important issue because we've got a situation where corporations are the main drivers of environmental damage, and yet it seems very difficult to hold them to account. So Matthew, I see that you've got your hand up.
Thanks. And I think that question flows on from Commissioner Cadiz's point that there is a role for national human rights institutions to actually perform an inquiry, but at the same time, that inquiry is merely the basis for further action. And already, I think there have been some processes in different jurisdictions to hold companies liable for environmental harm. In the UK, in the Supreme Court of the UK, in 2 cases recently, a Vedanta case and OHCHR case, both against Royal Dutch Shell, I believe, for environmental pollution in Nigeria. But the cases were brought in London because the plaintiffs alleged they couldn't get justice in the country where the pollution had occurred. And I think this is something that, where you could look at legal systems in Australia, New Zealand, France, if there are countries involved there, or the US, where companies have their headquarters and make those international companies liable for environmental harm and under the tort regime. But it also then, once you start making those companies liable for their environmental crime, it also relates to one of the questions asked by Asad Raza about eradicating the misconception that environmental human rights defenders are anti-development. We never will, because we are anti-bad development. It's just that most development violates environmental law and human rights law. And I always say that one of the problems when people talk about us being anti-development, I say, well, actually we're pro-law, but that doesn't help, because every time you're successful against a bad development or a development that is illegal, you are still accused of being anti-development. You say, well, actually all we've done is we've tried to enforce the law. Isn't that a good thing? But the development people, the pro-development at any cost people, are not interested in that. So that's always a challenge. If you're supporting good practices in environmental and social planning or human rights, you are always going to be perceived as being anti-development. It's just that the development that we're opposing is illegal or bad for the planet and the future. I mean, the issues of in the Philippines, just on the carbon majors case, have been quite significant in terms of the attacks on institutions and the Commission, because they're doing their job and finding and looking at investigating the environmental and human rights costs of the carbon majors.
Are there any other speakers who want to have a go at answering that question?
All right, I can add to that. So under international law, unfortunately, because there is still no, although it's under negotiation right now, there is still no international binding treaty that would hold multinational corporations liable under international law. So if we are to hold these companies for their human rights violations relating, for example, to the environment, they may be held liable under municipal courts, under domestic laws of those courts. And it is the duty of states to actually create laws and mechanisms to hold companies liable under their domestic jurisdiction, under their domestic laws for these violations. And these laws must be informed by international standards and as established under international law. So that is the state right now for holding them liable. They will be need to be held liable under municipal courts on the basis of the domestic law. And let us hope that sooner than later, these internationally binding treaties on the culpability of multinational corporations can come into fruition soon. Now, but having said all this, there are some encouraging developments in certain jurisdictions. For example, just recently in the Netherlands court ruled on a case filed against the Royal Dutch Shell Corporation, where the Netherlands court ordered the respondent Shell Corporation to engage in measures that would drastically reduce by 45% its carbon footprint by 2030 and to net zero carbon footprint by the year 2050. This is again an example of a municipal court, in this case the Netherlands court, applying international standards as was essayed under the Paris Agreement, and requiring a private corporation within its jurisdiction to comply with that standard. The court arguing that the Netherlands, being a part of the international community, being a part of the Paris Agreement, and being subject, being a party to the European Human Rights Convention, is bound as part by the provisions of these conventions as part of the law of the land, and therefore they may impose these international conventions on these corporations within their jurisdictions.
One of the issues that I wanted to raise, because I think it is actually an important issue in the Pacific region, and I think it goes back to some of those questions I asked about the role of UNDRIP, but Peter talked about some of the extraordinary principles that are in the Papua New Guinean Constitution. That Constitution was developed in 1975, and it was specifically an anti-colonial document that was driven by Papua New Guineans in response to Australia's colonial efforts. And it includes national development principles, including what Peter talked about, and including some very strong injunctions of maintaining sovereignty and integrity against foreign capital, and ensuring that the environment is preserved for future generations. But there's a very strong tension, and I think it's a tension across the Pacific between the former kind of colonial regimes, so common law, the narrowness of common law ideas of what the judiciary is, and then what the Constitution actually says. Because one of the things that judges are allowed to do in Papua New Guinea is that they're allowed to actually conduct their own inquiries into human rights abuses. And you can actually fill out a very simplified form to take a human rights case to a judge, but that mechanism hasn't really been developed in Papua New Guinea, because it also goes against the principle of the separation of powers, which is a kind of a legal imperialistic view of what the judiciary should be in PNG. So I'm kind of interested in people's views of legal imperialism across the Pacific, and that's why I said we need to kind of look at what we already have locally and try and strengthen our relevance. I'm just interested in what people's views are on that question.
If I could just intervene, this is Ben Boer. When you're thinking about local examples, if you look at the Philippines, which Roberto Cadiz has been talking about, you'll see that there is an Environmental Defence Bill of 2020, which includes provisions focused on the protection of environmental human rights defenders. And whilst that piece of legislation is still in the Parliament, it is a terrific precedent to look at for other countries that might have a better chance of putting it through their legislature than perhaps it stands in the Philippines. The other piece of legislation that is worthy of note is the Mongolian legislation, which has just been passed in April this year, on the legal status of human rights defenders. And that particular legislation is drafted broadly enough to include environmental human rights defenders. So that is really the first in this region of the first kind of legislation which focuses on this, which has actually been passed. But I just wanted to mention, if I may, just as a next point, is that in addition to the case that Roberto has just talked about in the Netherlands, it's also important to have a look at the case that was passed, that was handed down in the same week, just a few weeks ago, which is the Sharma case, which has got to do with placing a duty of care on the Federal Minister for the Environment in Australia concerning a coal mine. And there was the idea was to have an injunction to restrain the breach of the relevant federal law when approving extraction from coal from a coal mine because of the risk of injury from climate change. So there are two aspects here. One, in terms of innovative legislation, which Pacific Island countries, and for that matter, countries around the Asian region, should look at more closely, but then also to look at some of the basic legal mechanisms that are available under common law and statute, which can be pushed to their limit with respect to climate change in particular, but environment in general.
Are there any other questions or interventions that anyone would like to make?
Perhaps I can respond to a question that has been posed around what are the key steps for EHRDs to eradicate misconception amongst policy and decision makers that EHRDs are anti-development. And I think Matthew raised a really good point that, where there is bad development, will be seen as anti-development because such development does violate environmental laws and human rights as well. But there are a number of approaches, and the United Nations Environment Programme, together with the Universal Rights Group that was discussed earlier today, have started a good practices initiative to try and collect a series of positive stories and good practices to exemplify how EHRDs have been positive forces. There's also been other strategies. Of course, social media is a major tool these days. And for example, there's been a collaboration with Wikimedia to do a Wikistorm on human rights and the environment, to crowdsource positive data and information around the interlinkages between human rights and the environment. I thought that Catherine raised a really interesting suggestion during a session yesterday, which was to go where the people are, which is Netflix and other TV media, and have a documentary on the positive role of environmental defenders. This is just a hypothetical idea, but to change the dialogue in a way that uses mediums that are popular media, where you're going to reach a broad range of viewers, because it's not just about changing that perception amongst decision makers. The broader community needs to understand the importance and the role that EHRDs have to safeguard the future of people and the planet. And so there are a few collaborations and approaches that are happening. Also to note that there has been global recognition with the recent push towards a General Assembly resolution on the human right to a safe, clean, healthy, and sustainable environment, and discussions that have happened around that through the Human Rights Council has generated a lot of support, not only from member states, but now there's now a business declaration that has been started by a business organization where a number of businesses are signing to signify their intent to support the human right to a safe, clean, healthy, and sustainable environment. So I think there are a few different approaches. Maybe I'm a little bit more optimistic that it is possible to change the broader narrative, but a lot more work needs to be done.
I think that's a really important point. One of the things that we've been looking at, you know, we're bread and butter environmental lawyers, but actually communications is becoming something that we really think's important, particularly around protecting people on the ground who are trying to, you know, in Papua New Guinea, are trying to protect their environment. And so we've been in conversations with documentary filmmakers about these kind of things. But also another audience, and I think one, you know, because Ben mentioned the Sharma decision, the importance of that actually is to see how a rational decision maker deals with the science of climate change, because we actually are at the crisis point, and you can see that that decision maker actually realize what the implications will be for them, probably their grandchildren, and you know, family members. So that was a very interesting thing, and that gave me a little bit of hope in relation to how science can be used effectively in the courtrooms in relation to some of the issues that we're facing. On that note, we've come to the end of the session, because there's a closing session that's coming up next. But I wanted to thank our 4 speakers today for a very interesting and important discussion. And I think procedural rights obviously are the fundamental building blocks for good environmental law, and also for people to be able to fight for and protect their local environments. And it's very important in the Pacific, and obviously it will be something that we will continue to discuss going forward. So.